Hello. Now, the Presidential Election Petition Tribunal declared yesterday in her judgment against the petition filed by the Labour Party that of the 13 witnesses who testified for Peter Obi of the Labour Party, only 3 of them to be reckoned with because the evidence of the remaining 10 of them, which was evidence by persons on subpoena, were defective in law. So, first of all, what is a subpoena? A subpoena is an order of court compelling the attendance of a person to court in a matter, either for the purpose of giving documents that are of interest to the parties or the court in that case, or to give evidence that stands in like manner. When a subpoena is for the purpose of giving only documents, the person under subpoena is not required to testify. He just presents the documents and walk away. That kind of subpoena is called subpoena duces tecum. When the person is required to come and give oral evidence, that person can be cross-examined by the other party, apart from the party at whose instance the court has called such a person. Such a subpoena is called subpoena testificandum. Where the party is required to do both things, it is called subpoena duces tecum ad testificandum. Now, in usual parlance, courtroom parlance, we say that a subpoenaed witness is the witness of the court because that person has come to the court at the instance of the court itself. The tribunal said yesterday that since the Electoral Act requires that all evidence must be filed within 21 days after the election being complained of at the tribunal, that since these persons under subpoena did not file their documents during that time, their testimony and the documents ought to be expunged. With the greatest respect, I do not think that the court should have gone this way. This is why. At the time of calling those witnesses by the court, the parties, although they may have an idea of what they want that party come and declare or say before the court or produce before the court, they cannot be certain that the parties or the persons would have said exactly so and so, or that they have so and so documents to produce. Therefore, the party at whose instance the court subpoenaed those witnesses could not have even had that testimony or the documents. A practical example in this same case is where the chairman of the Electoral Commission was subpoenaed but sent someone to replace him, whose testimony would have been filed at the commencement of trial or a filing, if at all the Labour Party had known that any of them was going to come. Let's say, given that kind of an example. Again, that same person that appeared on his behalf tendered some documents and didn't tender others. He said it would have taken them more time to get it. Which of these documents were the Labour Party expected to have gotten ahead of time? Again, like we said initially, a subpoenaed witness is a witness of the court. It means that the court must have acted to order or compel their attendance to court. Within 21 days after the election, remember that the tribunal had not been constituted nor inaugurated. I wonder who would have made the order of court to compel those witnesses to bring their documents, would have formed part of the record. I also know that the registrars of court, or of the tribunal in this case, do not have the powers to make or compel witnesses. So it's not possible that they could have made those orders on behalf of the court. It accords with my reasoning that the evidence of such persons could not have been gotten within the 21 days' time. Therefore, it would not have made sense to have had those documents. After all, if they did have them when they wanted, what would have been the need to compel their attendance or their production of those documents? So, no matter what the Electoral Act has said or put forward, I do not think that it is practicable to insist on that particular provision that all documents must have been filed within 21 days of the election conducted or being complained about. Remember the maxim that the law cannot compel the doing of an impossible thing. It's been Ayede School of Law. Thank you.